everyone. My name is Dr. Elinor Carmi. I'm a lecturer in media and communication at City University. I'm also the sort of the media officer of GigaNet. It's really great to see all of you here. And this panel is panel 1B, which is called the governance of privacy. And the way that we're going to do this, I'm going to be quite strict on the timings. Each sort of paper will have 8 minutes. So I want you to think of this as sort of like an introduction to your concept. So don't feel bad if you're not going to do or manage everything. It's okay. We're here to just sort of show and flag your work. That's okay. If you have any questions, we're also going to have time for questions at the end. And of course, the discussant who will also make comments about everything. So why don't we just dive in? And Chelsea, who will talk about her paper, Dark Patterns in Privacy Harms, Accountability and Agency in an Age of Disappearing Privacy. Yeah, also if you can maybe send me a message if you have your preferred pronouns as well. But yeah, Chelsea, can you share your slides?
My paper is titled Dark Patterns in Privacy Harms, Accountability and Agency in an Age of Disappearing Privacy. I'm Chelsea Horne. I'm from American University, and I'm very excited to be here. So thank you so much to GigaNet for having me, and also thank you to Dr. Carmi for being the chair of this session. So just as a brief setup, as I know that we're all very well versed in this, but that internet-related companies have become incredibly powerful because they not only provide the services, but they shape the digital spaces upon which citizens increasingly depend. And there's this idea of privatized governance from Laura Denardis and Andrea Hackle, that social media platforms, policies, and technical design serve as a form of privatized governance, directly enacting rights and regulating the flow of information online. So I'm interested in privacy settings. I see privacy settings as a site of power. And they're interesting because there's many places where platforms engage with privacy online, the terms of service, the privacy policies, the actual technical infrastructure. But this privacy settings themselves are this interesting, visible, interactive privacy architecture that's a point of tension between the user and the platform itself. So I find them very interesting for that fact. The literature widely shows that settings do have immense power. They're able to influence user behavior. And at the same time, most users do not change their settings, with rare exceptions when there's feelings of high self-efficacy or when there's been a privacy violation. But for the most part, we have those two key points there. And also why I'm excited that Dr. Carmi is here. I'm understanding her idea of the myth of the empowered user, that there's this farce of individual responsibility with the ways that privacy settings are framed by platforms. And so the platforms themselves, and even policymakers a bit, they focus on the user interaction with settings. This paper, I'm interested on looking at it from a different perspective and seeing how the platforms themselves deploy settings in response to social, economic, and legal inflection points. So I'm doing this within the framework of dark patterns, which is an emerging concern. Back in 2010, the Brenden defined dark patterns as tricks used in websites and apps that make you do things that you didn't mean to. So a famous example is what's quote privacy zuckering. There's more nuanced variations and definitions of dark patterns terminology developing now, but it's based on a robust literature, like from law. The same premise of dark patterns is called sludge. We have market manipulation from the behavioral economics is sludge, and law from is the market manipulation. And so looking at dark patterns in platforms, in online services, is a way of having a lens to look back at bringing fairness back into the online world. And there's been some proposed regulatory actions along these lines, such as the Detour Act in the US, the Deceptive Experiences to Online Users Reduction Act, and then in 2018, the Italian regulator and also the German court penalized and fined Facebook for these deceptive practices, misleading practices. So this paper is using a framework developed by Mather et al. And that paper, it compiles the literature on dark patterns and it identifies certain attributes. So there's two main kinds: alternating decision space, where we have asymmetric and restrictive. Those two, they're bolded there. are because that's usually where the privacy concerns come up in terms of settings. So usually difficult to navigate settings or bad defaults are usually one of those two things, or the lack of choices to begin with. And then the other one is the manipulation of information flow, which is information hiding. So putting options way behind really difficult to navigate settings. And there's four normative lenses. We have individual welfare, collective welfare, regulatory objectives, and individual autonomy. So these dark patterns frameworks help frame the most common and most concerning issues in deceptive practices currently. So the data set for this paper, I was looking at Facebook newsroom articles from 2006 to 2021. So basically from the beginning to the present at the data collection point. So I was looking at all articles having to do with privacy in general. So information, announcements, updates, anything to do with privacy. So overall, there was 115 articles. Of those 115 articles, 76 specifically addressed privacy controls, and 30 articles announce changes to privacy settings. So that's 30 changes over the course of 2006 to 2021. So I analyzed these articles and these updates to privacy settings within the dark patterns framework as a way of looking at what are the privacy issues that Facebook is most concerned with when making these settings updates. So here we have it broken down by year. I found that for the most part, the updates themselves were framed within the context of individual welfare, so that the changes were a way of allowing users to enhance their experience online, but at an individual level. There's a few that were updates that were based on collective welfare. And so those ones more about thinking about privacy settings as helping the entire community, as opposed to an individual responsibility and the options that are available to the individual. So just as a quick focus in on a couple of things here to look at the kind of things that are being changed. 2010 was a massive simplification that Facebook called it, where they reduced the overall number of settings required to make all information private from nearly 50 to less than 15. They consolidated 10 settings to 3 separate pages, and they kept reducing everything down from the more options into more simplified and, in theory, easier to understand controls. At the same time, the Electronic Frontier Foundation dubbed that exact change as an evil interface. And so that sort of launched off the discussions of deceptive interfaces in terms of privacy settings. In 2012, Facebook introduced more privacy shortcuts, improved in-product education, and also in 2013, a year later, they changed, and this was an important change, the default from public to friends. So this means
you
that
have 1 minute, Chelsea. I'm just reminding you.
Perfect. I'm just about done. Switching from public to friends is a pretty significant change because it's showing a huge normative shift in how Facebook's responding to evolving privacy concerns. So just to wrap up, so thank you for that. Overall, over the course of the entire time of Facebook, we have 30 privacy updates, but most of them took place within the past 4 years. A strong majority of these updates focus on a normative lens of individual welfare, where they're framed as being simplified and easier to find. What this addressing concerns over the obscure and difficult to navigate settings, and within this frame of individual responsibility over the choice and control of users. The collective welfare lens, on the other hand, addresses the concerns over the available options and defaults, and it primarily focuses the issue of privacy settings as a platform's concern, as a platform's responsibility to offer good settings to its users. So I'll wrap up right there. So thank you so much.
Thank you very much. This was a really interesting presentation, and I'm reminding you all again, if you have any questions, and please put them in the chat. You'll have approximately 10 minutes at the end to ask questions or comments. And we also will have Dr. Oksana Radu, who will also give her notes on the presentations. And let's not waste any more time. I'm just reminding you that we are panel 1B, the governance of privacy. And now we're going to move on to Dmitry Epstein and Rotem Medzini, who are going to talk about privacy by debate, a content analysis of post-Cambridge Analytica congressional hearings. So the floor is yours, and again, 8 minutes from now.
Okay, thank you, Elinor. I feel the pressure. It's been very, very short. So thank you very much, Elinor, and thank you, Chelsea, for this excellent presentation. I think ours will serve as sort of continuation of this discussion. This is a joint project together with Rotem Medzini, where we look at congressional hearings that followed the Cambridge Analytica scandal. So this presentation has 5 steps, which I'll try to squeeze in. I'll tell you a little bit about how we think about privacy, about the case, how we studied it, and what we found, with some questions and observations. So we start with privacy. The way we approach privacy in this project is by differentiating between the vertical and horizontal relationships, privacy relationships, where vertical relationships refer to the privacy vis-a-vis institutional actors, and the horizontal ones are about privacy vis-a-vis peers. Additionally, we also think about privacy in terms of proximity of those relationships, meaning primary privacy relationships with when an actor makes conscious or arguably conscious decisions about sharing or not sharing information with an institution or peers, and secondary relationships when this information is further reused, repackaged, reanalyzed by and reshared by those peers or those institutions. Our theoretical perspective is that of framing, where we look at frames as those schemata of interpretation or central organizing ideas for making sense of complex problems such as privacy. And here again, we distinguish between 2 types of framing. One is frames in thought, which delineate the realm of the possible or desirable, or restrict and prioritize sets of available considerations. And we also look at frames and communications, which are kind of expressions of the said frames, and that includes expressive behaviors of the media, like we saw in Chelsea's paper, and also that of policymakers. Specifically, we're interested in framing privacy by political and technical elites. We think that these are particularly important as this is the elite discourse where privacy is strategically constructed and deployed into public discourse and also into policy work. And despite growing interest in framing of technology and technology policy, research on actually privacy framing in policy discourse is relatively scarce. Previous research that did look into it suggests that there may be different ways in which elites and the public look at privacy. Whereas public tends to prioritize horizontal views of privacy, the elite discourse tend to emphasize the vertical relationships. So against this background, we ask, how do elites frame privacy? And whether we can point at any differences in framing by different stakeholder groups within those elites. So we use Cambridge Analytica as our case. I assume that many of you have heard about this case when massive volumes of data about Facebook users were collected, mostly without their consent, by Alexander Kogan and Cambridge Analytica. And later, these data were used to influence voter behavior. When story exploded, it caused international outrage, and among different responses, there were 2 hearings held in the US Congress where senators and members of the House questioned for a few hours a single witness, Mark Zuckerberg, the CEO of Facebook. And that's exactly what we studied. So we looked in this paper, we talk about our analysis. I need to move stuff on the screen to see what I'm talking about. So we focus on the April 10, 2018 joint session of the Senate Commerce, Science and Transportation Committee and the Senate Committee on the Judiciary. So you see on the screen some of the descriptive statistics of participation and the volume of that participation. What we did in this paper is that we took this hearing, which is a very structured event, right? Every committee member gets a 5-minute segment where they can ask the the witness pretty much anything that is related to the topic, broadly defined, and the witness responds, but they cut off at this 5 minutes. So we had this neat 5-minute chunks of where Mark Zuckerberg interacts with the members of the US Senate. We applied Stromer-Galley's idea of thoughts to unitize our database. So we basically looked at all these interactions, and we only included in the analysis those that included thoughts about privacy. And I can talk more about this later in Q&A, but we ended up in this particular hearing with 69 exchanges between the senators and Mark Zuckerberg. We used a deductive approach where we operationalized a number of, we either adopted or operationalized a number of ideas from privacy and framing literature. And we basically coded each such variable for a series of indicators, a monitoring for agreement, intercoder reliability, and eventually we ended up with a series of composite measures, some of which you can see currently on the screen, and those are the ones that I'm going to discuss in our findings. So here's a quick overview of what we found. So perhaps unsurprisingly, this hearing was dominated by a vertical privacy discourse, right? It was also more frequent, and it also was kind of richer and more dominant compared to horizontal references, compared to references to horizontal privacy. When we compare Mark Zuckerberg's references to those of the senators in terms of orientation, we find that vertical framing was relatively more common and stronger among the senators, while the horizontal framing was more common and stronger in Mark Zuckerberg's discourse, which I think connects directly to what Chelsea was talking about, how Facebook presents its privacy changes and settings.
I have 1 minute.
Okay. We can also observe ideological differences. We can see that the Republican senators tend to look more at primary relationships, whereas Democratic senators are looking more at secondary relationships, which is interesting given that the hearing itself was triggered by a secondary event. We have more ways of looking at this data that kind of verifies the same idea. When we look at the responsibility attribution framing, Mark Zuckerberg used the protection frame actually more frequently than the senators, more frequently than the infringement framing, which is interesting because it's sort of taking nominal responsibility for Cambridge Analytica without placing blame. At the same time,
Time is up, Dmitry. I'm sorry.
Okay, I'm actually have one more slide here, which summarizes our main findings, and I'll stop here. Sorry
that I'm being very ruthless today because I really want us to have the discussion, and that's the main thing. And if people want to sort of pry a bit more, then they can do that in the Q&A. So thank you very much for this. We are moving swiftly to the next presentation by Yangkun, Huang, and Sini, who are going to talk about when web crawlers infringe personal information, judicial evidence, legal governance, and legalistic swamp of China.
Hello, everyone. Ladies and gentlemen, it will be a great honor for me to have the opportunity to share my recent empirical research based on China legal documents. I'm Huang Yangkun from Shanghai Jiao Tong University, and my co-author is Sini from Zhejiang University. And our topic is when web crawlers infringe personal information, judicial evidence, legal governance, and the legalistic swamp of China. Starting from the status quo in China that big data technology developing rapidly and web crawlers used widely, bad boards have undoubtedly become a present danger to citizen state privacy to Chinese citizens. We conducted a content analysis on 103 criminal cases of infringing upon citizens' personal information referred to as IUCPI in this article. Specifically, we coded details in these legal documents and tried to answer the following questions. The first one is word-based features are there in criminal cases of IUCPI by web crawlers. The second is word-based features are there in sentenced defendants in the crime of IUCPI by web crawlers. And the third is how are the relevant provisions of the crime of IUCPI expressed in the application of current Chinese laws. Last but not least, what is known about the governance experience and judicial dilemma in legal practices of the crime of IUCPI by web crawlers. Okay, before I'm going to introduce my results and contributions and conclusions. I was going to talk about uh, the crime of infringing upon personal information in China. In China, whoever sells or provide any citizen personal information in violation of the relevant provisions of the state shall, if the circumstances are serious, be sentenced to imprisonment of not more than 3 years or limit in capitation in addition to a fine or be sentenced to a fine only. Or be sentenced to imprisonment of not less than 3 years but no more than 7 years in addition to a fine if the circumstances are especially serious. Okay, uh, before we introduce our results and conclusion, it's worth mentioning that all full text legal documents for this study are retrieved from the China Judgments Online website, the globally largest open and continuously updated database for judicial documents. And the specific data collection method and the coding scheme are both displayed in this slide. According to our coding, we find some basic descriptive results that firstly, uh, the crimes IUCPIY web crawlers mainly occurred in eastern China and are committed with a high frequency in 2018. 2018. Uh, as a whole, peculiarities of 288 criminals portraits are concluded. Middle-aged male, geographically dispersed, high educated and unemployed. And second, in terms of court outcomes, out of 129 offenders, IUCPI were identified as serious circumstance, while the other 159 involved the especially serious circumstance. The result of our coding of legal facts show that the telecontact, for example, the phone and telephone numbers through which people can be reached directly, although identified regularly, is most frequently infringed PI type, and 33 out of 103 cases are related to its illegal theft. Besides, warning signals are worth noting that at present, more than half of criminals have already participated in multi-stages of IUCPI, from 12 development, data crawling, and to data exchange and sales, even to follow up illegal activities, including lending, fraud, and selling medicines. Okay. However, secondly, our research reveals poor differentiation in okay. Uh, okay. Here is the non-parametric test for answering our core questions. How are the relevant provisions of the crime IUCPI expressed in the application of current Chinese laws, and what is known about the governance experience and judicial dilemma and legal practice of the crime of IUCPI by web crawlers? We did a non-parametric test based on our coding results. Firstly, as expected, results of the main Whitney U test indicate that there are significant differences both in the sentence length and fine between the two systems. It's perfectly logically that the Kuerbis test also reveals significant difference in the sentence length and fine across 4 levels of the amount of the PI infringed. And significant differences are the same significant across levels of the money involved, which means there is no apparent deficiency in the application of current Chinese laws. I think it will be a great experience for the data governance for other countries. Okay, However, secondly, our research also reveals poor differentiation in sentencing and conviction among extreme cases where not so much or too much PI involved. The details are displayed in the tables. Okay, and thirdly, what's more, we find that about the money involved, the figure of sentence length between levels seems to be differ less notably, and even the difference between the first level less than 1,000 and and the third level is unremarkable. Yeah, just displayed in this just displayed in this table. Okay. There are also significant difference in punishments between the acts of only legally obtaining PI and the other two illegal behavior patterns, and it is a tendency that the legal sanction for the acts of OIO, yeah, the only illegally obtaining PI are less severe.
Have one more minute.
Okay, here is our discussion. Firstly, subjects of the crime are geographically dispersed, well-educated, and group-related. And second, the information types that can be used to make direct connections with individuals, like phone numbers, have become the main target of spider bots. Secondly, the whole crime chain of the IUCPI wire crawlers has been completed, and many defendants almost participate in more than one segment of the crime chain. Okay, going back to our core topic, the core outcomes research aims to make 2 points. There is not apparent deficiency in the application of current Chinese law. And the second, 2 common problems of conviction and sentence, the lighter punishment and the insufficient differentiation cannot be avoided. Here is our conclusion. First one is necessary to refresh and update the sentences standard of IUCPI.
Sorry.
Okay.
Your time is up. I'm really sorry.
Okay. Thank you so much.
Thank you so much for this amazing presentation. And now we will swiftly move on to what looks like the last presentation, which is fantastic, by Brenden, Kuerbis, and Milton Mueller. I hope that I'm pronouncing your names right. Your presentation is Making Data Private and Excludable, a new approach to understanding the role of data enclosure in the digital political economy.
Thank you for the invitation and the opportunity to present our work. So our work highlights how encryption in the DNS and major platforms' limitations on ad tech are part of a much broader competitive struggle over the economic value of data. This push for exclusivity of data is fundamental to current internet debates. It's relevant not only to privacy and data protection law and regulation, but also concerns about platform competition, cybersecurity, and content regulation. Political economists have recognized the importance of property relations in shaping the way the economy works. Property regimes evolve in response to socioeconomic development, and then they're consciously modified in lines with notions of public policy, justice, etc. In the new institutional economic theory, competitive forces alter institutions that aren't congruent with economic growth. A key and enduring aspect of the concept of property is exclusion, allowing the owner to capture value either by using or trading it. Even in resource regimes where exclusion is difficult, like common pool resources, collective rules for appropriation can be defined. But what is the role of property in data? Data protection and privacy law could be characterized as an attempt to assign exclusive property rights and personal data to the individuals to which the data refers. And other legal scholars have resisted classifying privacy as a data property right because the replicability and many potential uses of the data make it impossible for the seller to know exactly what they're giving away, and or because property rights regimes make it too easy for individuals to transact their privacy away. But more recently, legal scholars have recognized that modern information economy platforms are fostering a quiet revolution in the legal status of data as proprietary informational property. Yet even if the complex notification and consent regimes of data protection law are not intended to facilitate exchange, they rest on a creation of an artificial, legally mandated exclusivity, just as copyright protection does. Encryption, on the other hand, is a technological means of creating exclusivity. Private contracting is another approach. Both can erect a fence around digital data that restricts access, shifting resources toward becoming a private good. So many communication networks have experimented with or deployed protocols or other mechanisms to make valuable data excludable. Over-the-air broadcasting is the paradigmatic case of a public good. In the 30s, Zenith Television didn't believe that government or advertising sponsorship would be able to support an adequate number of stations. Its phone vision system was launched in 1947 with broadcast over-the-air signal that was jittered and decoded with the first set-top converter box, thus excluding non-subscribers. However, pay television never materialized. More than 30 years later, newly formed satellite-based cable television networks in the US were in furious competition. A significant problem was that the network's programs were distributed in the clear by satellite to cable system headends, which meant they could also be received or even retransmitted by any other person with a properly tuned dish. That created a free rider problem for the content producers, domestically and transnationally, despite copyright treaty. The Cable Act of '84 permitted cable networks to encrypt their satellite feeds, enclosing that data using the video cipher so that only end users that purchased a decoder from a satellite provider could receive the channel. And that encryption prevented signals from being observed from non-subscribers and created a burgeoning global multi-billion network security industry providing conditional access. Fast forward a few decades to the 2000s, the internet's DNS became the object of data enclosure efforts. Clear text data, traditionally DNS queries took place in the clear text. Neither the queries nor the transport of the messages were encrypted, and nor were the endpoints of the communication authenticated. This data could be monitored by networks along the transmission path. It was susceptible to interception, blocking, modification, taking place for a variety of business, network security, or legal requirements. Clear text data could be viewed as a club good. Query data had low excludability, being available to network operators, typically the user's ISP, running recursive resolvers between the user and the authoritative resolver operator. Like information generally, the data was also mostly non-rival. It could be used repeatedly for different purposes and even retain its value over time. These characteristics led to the creation of positive and negative externalities. For example, the sharing of ISP query data with network security providers and content delivery networks resulted in DNS-based protection from malicious websites, as well as optimization of content delivery. Advertisers' use of query data also provided users more precise and efficient search-based advertisements. Almost a dozen market segments totaling 940 billion produce or consume DNS query data, as shown in the slide. But the use of the query data also resulted in normative, if not legal, violations of users' privacy. For example, an ISP that provided query data to third parties serving advertisements eventually faced legal action from regulators. A European data DPA found that the DNS query data processing to be illegitimate, if not compliant with GDPR. And DNS query data sold to researchers has been allegedly used inappropriately for political purposes. Into that environment entered DNS over HTTPS, or DOE. Published by the IETF in 2018, it uses the same protocol used for secure web pages to transport DNS queries between the application stub resolver and the recursive resolver. Its deployment made DNS queries look like any other HTTPS traffic over port 443, making it difficult to isolate them. It provided confidentiality for DNS data while in transit between authenticated endpoints, making monitoring, blocking, and modification of the queries by intermediary actors more difficult. And it allowed DNS queries to bypass the local ISP and be handled by a recursive resolver run by a cloud service or an application browser provider.
I have 1 minute.
For instance. Thank you. Finally, the mobile internet digital advertising market and the variety of industry players it involves has been consumed by efforts to enclose protocol data used in the mobile device operating system. Similar to the unique cookie identifiers, the iOS identifier for advertising and Android advertising ID have been used to identify and track users' mobile devices across different apps installed on the device, deliver personalized and targeted advertising, measure campaign performance, etc. Apple and Google control who use the IDFA and AAID and how they can use them through the App Store and Play Store platforms' contractual agreements with users and application developers. And beginning with Apple 14.5, iOS 14.5, Users must now opt into app developers' requests to use the IDFA to track them across apps owned by other companies. Google,
Sorry,
on the other
Brenden,
hand,
your
allows...
time is up.
Okay, I'm going to jump to the conclusion. So competitive forces are altering data property relations in important ways, entangling economic exclusion and competitive advantage incentives with privacy or confidentiality considerations. And much like the earlier episodes, the creation of property rights in DNS queries and mobile identifiers stands to create highly consequential disruptions or adjustments in the existing digital economy. That's happening at the same time as norms, policies, and laws governing data protection and privacy are undergoing dramatic global changes, and platforms are coming under increasing regulatory and antitrust scrutiny. While the DOH scenario seems to have worked out, the situation with ad tech mobile identifiers is more unsettled, and the enclosure of ad tech data forces upon us a more direct consideration of the trade-off between privacy-enhancing technology and competition policy concerns. The most interesting questions about the future, however, arise from the degree to which data enclosure efforts often succeeded in responding to consumer and government demands for better privacy protection. Google's refusal to leverage the dominant market share that it has in browsers to capture DNS query data, instead allowing access of any DOH-enabled resolver, indicates that it's more motivated by cybersecurity and confidentiality than the desire to exclusively control data.
Brenden,
Apple
I'm
is
really
also
sorry,
clear-
but you're way over the end, so I have to interrupt you. I'm sorry. Thank you very much, everybody. I think this was a really great, a lot of presentations, which really showed us that privacy means different things in different countries for different people and legislators. And now we will move to Dr. Roxana Radu, who will have a few sort of insights into the papers as a discussant. And if people have questions, that I really recommend you to start writing them in the chat so that we can talk about them after Roxana. So Roxana, the floor is yours.
Thank you very much, and thank you to all presenters for shedding light on their very interesting research. I will provide very quick comments because I was called in last minute to replace our previous discussant, so I did not have a lot of time to engage with the papers, but I hope the comments that I can provide today can still be helpful. I very much appreciated that all papers came together to talk about this lack of accountability that we're seeing in the privacy discussions with regard to the tech sector, whether that's at the technical level or more at the level of policy that they impose, which then in turn shape our behavior online. So it's very much going in the direction of power structures and how that might be reflected in legislation or in day-to-day practices by various companies. This setup also challenges what Elinor has referred to as the myth of the empowered user. We are at a very mature point in these privacy conversations to realize that whether we give users a little bit of control over some settings in their profile, or we tell them they get switched to another resolver, that might not mean they end up being empowered. So it's refreshing to see the empirical evidence that goes in that direction, questioning the extent of private governance and really talking about these paradigm shifts we are witnessing. I'll go through a few individual comments for each paper, but again, I will keep it quite short. I appreciated Chelsea's paper that talks about the evolution of privacy through the lens of privacy controls. And I found it was extremely insightful to see the gap between the promises and aspirations of privacy and the reality of a business model in which everything is monetized. I also liked her engagement with the concept of dark patterns and the different forms that might take. I think it's worth questioning here whether we want to think of it as dark patterns or we want to categorize that with a legal lens and say some activities are purely illegal rather than undefined dark. So it's a question to you, Chelsea, if you see some scope for further categorizing these dark patterns into what that actually means in relation to legality. And of course, the focus on Facebook is very welcome, because there is a lot we can say about Facebook being the largest company in this space. Yet it would have been very nice to compare this with other market players that provide social network platforms, just to see whether Facebook determines the market, whether whatever they impose will be actually picked up as an example or as a way of doing things. I guess it's quite important for the rhetoric of choice and control. If everybody aspires to provide the same level of minimum control as Facebook does, then we can see the problem for the entire market. I felt you could have done more to extract additional findings from your data that was extremely rich. And maybe if there was a possibility in the future to add something on cases outside of the US and outside of the FTC jurisdiction, that might bring in additional perspective with regards to dark patterns. So if you think about some of the cases in Europe, for example, Facebook was also taken to court for the cookies they installed to track users on other sites that they would be visiting. Also in terms of the recent revelations by Francis Hogan and others about Facebook activity in other jurisdictions, I think it might be interesting to add that, maybe not to complement the analysis you currently have, but just to add examples here and there to show the scope. And if we go back to this idea of an accountability framework that we might aspire to, maybe in the conclusions you want to reflect back on what we have learned in this process. Are fines truly powerful sanctions, or simply the cost of doing business? Is there anything else that we should be thinking of when it comes to user controls? Quickly going through the paper of Dmitry and Rotem. Thank you very much for this extremely interesting read with a very insightful title. I found, Privacy by Debate. There's a lot to debate around it. I felt it was providing new perspectives, but I also had a few questions. So to start with, I can challenge one of the observations you make in the introduction, that Cambridge Analytica has resulted in systemic effects for privacy and perhaps for democracy. I like to push back on that one and ask you to provide more evidence that this is the case. I think we have very mixed results in the aftermath of the Cambridge Analytica scandal. So yes, we've seen more attention, but as you rightfully point out in the paper, not enough academic attention to the issue, but not as many systemic changes as we might have expected to see. So in that sense, there's probably something else you can explore there as to why nothing has actually happened. And with regard to the social role of privacy, I think you're doing an extremely interesting analysis. But I was wondering if you might want to add a section on privacy as a fundamental right, which is not one of the frames that you are specifically looking at in the paper. Are there legal and constitutional elements to it that maybe should come out in the debate? I felt the focus on elites needed to be a little bit better explained, because we didn't necessarily find very clear the distinction between decision makers and elites, and what does that mean in relation to a single witness when you take the Facebook founder and CEO. Do these elites stand for other communities, for stakeholders, and in that sense, what's their representativeness? And again, a comment that I made for Chelsea's paper as well, if you have a chance to add a comparative perspectives and look at an element from outside of the US context, for example, the hearings in the European Union or in other places, I think in the UK as well, they've had similar discussions. It might be worth comparing some of those frames, even if you don't necessarily need to collect as much data and do a systematic analysis of all those other debates, it might be useful to refer to the main outcomes of those discussions. And a final point about the tone of the findings, I found it was quite hesitant towards the end. I think you have enough evidence to actually strengthen that and say there's a correlation, there's a causation here, and we're actually seeing this with a lot of confidence. When you come back to the notion of self-regulation in the shadow of hierarchy, it leaves me wondering whose shadow it is and how the hierarchy actually looks like, who is finally in control. I think we like to believe that Facebook was shaken by these congressional hearings, but again, going back to the question of what has actually changed, are we not still living under the shadow of Facebook making the rules? That's a question for you to see if there's the scope to explore it further. Moving to Yangkun and Sini's paper, I found it provided fascinating insights into legal cases, and we're actually missing this in policy discussions, this empirical evidence of how some of these pursuits of infringements work in practice. So it was very welcome from my perspective to have this type of analysis. And abuse and infringement obviously happens everywhere, but China is an area that it's always presented, let's say, with less, at least in the West, I can say this, it's less in the focus, and we tend to have specific framings of what happens in the Chinese context. So it was refreshing to see something based on legal cases there. I greatly appreciated the empirical analysis. I think I learned a lot from reading the paper, and also information on how criminalization works and who might be behind those offenses. And I was wondering if you could provide more explanation as to why there is an increase of violations of the law in Eastern China primarily. Why is that so? What kind of correlations you're able to make there, or even explanatory concepts you're able to deploy to explain this? In connection with the recent debates elsewhere, I was wondering if China has at the moment a discussion regarding protections available to users to remove this information from where it sits online. So whether there's something similar to a right to be de-indexed or a right to be forgotten, where you can actually ask for your data to be taken down or not indexed as part of what search engines would do. And relatedly, whether there is an ongoing discussion about advantages and disadvantages of thinking in terms of individual and collective rights over personal information collection. I think we are at a point now in the global discussions where we start distinguishing between personal data that has a particular set of safeguards around it, but also collective access to metadata and what value that might hold, actually, whether it can even be seen as personal information. So I'm wondering if you could clarify some of this and just give us an update on where the discussions are standing right now. I very much appreciated that you engaged with policy recommendations at the end of your paper. And when it comes to Brenden Milton's paper, I have quite a few comments that come from how we might want to see this market. So I've written a paper in the past on the topic of consolidation of DNS resolver markets, and I found that it complemented very well some of the tenets you had in your paper. So the focus on the political economy of data is very much welcome. And again, we're having lots of discussions around governing data without necessarily taking into account the full picture, looking at all the economic transformations that come with that. So I appreciated it, and it was refreshing to see this focus in your paper. I do think it triggers a larger debate over the value of having a decentralized market. You're saying in the paper that alternative DNS resolution services are available to end users, but of course we know that they need to be a little bit tech savvy in order to implement that on their own computers. It's also important though to recognize that this is not a market that will be changed by users adapting their resolver services. It's more a market that is configured by either ISPs, internet service providers themselves, or by the open resolvers that have right now more than 50% of this market globally. So when we talk about, again, going back to user controls, I think it's a very limited alternative to the systemic changes that we're seeing. And you're talking extensively about the introduction of new standards and protocols for DNS protection. And of course, that comes with data advantages. But I'm wondering if you might want to complement your analysis with a look at who creates the standards and how they come into being. Of course, the IETF discussions are the place to go for this, but you'll see very soon that many of these proposals come actually from the companies that have the upper hand in the market. So complementing the information about what's to be gained out of data enclosures with who is actually designing our way of thinking about these data protections would actually be very appreciated. And yeah, a look at what is happening in the design of these standards is what I think would make your point even more pertinent. And with that, you can go back to what it means for the data economy, in which we are left with very few public controls. Thank you very much. I'd like to stop here and give the floor back.
Anna, I think that you muted yourself towards the end.
Oh, sorry. Okay.
But I don't know. Should we give the speakers a chance to answer and then we go to the Q&A, or what do you think?
Sure, we can do that. Yeah, absolutely.
Okay, so let's go according to the paper's order, if it's okay with you. So Chelsea?
I want to thank Roxana for your very thoughtful and albeit quick turnaround. So thank you especially for your really great feedback here. I absolutely agree. I think there's a way of looking at the dark patterns, which is right now, I think, an emerging language of the way that we're looking at deceptive and misleading practices. But there are certainly questions of legality and illegality at play here. So I think that's an opportunity of looking at the language being applied, such as dark patterns, to regulatory and policy action in the future. So I think there's a way of merging those two. So I absolutely agree. And I'm trying to make sense of my scribbled notes here. And yes, and the next step of this project will be to do a comparison study like you're suggesting here, to see because Facebook as the oldest one has the longest scope to see the history, but to look at maybe not ones that are as big, such as Twitter, but other mainstream ones, more recent ones, such as TikTok. I think it'd be interesting to see the evolution, if there is any, of privacy settings over the course of those different those companies as well. So I think a cross-platform comparison would be really useful and robust take on it, especially considering what's Facebook's role in establishing privacy settings, privacy controls, which is what they claim that they do. And then yes, in cases outside of the US, 100% agree will be a really important contribution to include. So just very briefly, but thank you again, Roxana, much to think about.
Let's move. Sorry, Dmitry and Rotem, do you want to have sort of
Sure. So just to quickly touch on some of the questions that Roxana raised. First of all, thank you. This is like, given especially the time, this was very substantive. So really appreciate it. Some of the points, such as, for example, looking at privacy as a right that was missing from our analysis, we actually did code for this. It's just not included in this particular manuscript. It was apparently not as, I think, if I remember correctly, not as prominent in this discourse as one would have expected. Thinking about it's a very fair point about the elites, and actually, like, a few of your questions, if I will bundle them together, this idea of kind of focusing on a single witness as representing the elites and kind of focusing on a single, basically, discussion, right, to draw any conclusions. So yes, you're absolutely right. In kind of our defense, I would probably say that Mark Zuckerberg is a unique player in this field. But we do have in the plans kind of expanding this analysis into looking at also additional hearings, but also hearings outside of the US, as you promptly suggested. Rotem, do you want to jump in?
Yeah, I will add to that I think one thing about calling them elites and not just like policymakers is one of the side effects of the literature on political powers or regulatory powers of platforms. And so we kind of try to, in a way, kind of give a more general terminology for both policymakers and private actors like Facebook, which have a lot of regulatory powers in the literature. So we might need to kind of clarify it better there in the paper, but I think that is kind of a more general term to use instead of
and just there. Maybe to add a teaser, so because we did code this the second day of the hearings as well, and we can see how there we were just discussing it the other day, how there the discourse shifted more towards horizontal privacy orientations as a response to points made by Mark Zuckerberg during the first day of hearings, right? That kind of shows the, I guess, like again, like disproportional impact this single player has, at least on the discourse in this setting.
Right, and the other point here is that the good thing of having one person, one witness, is that when we just start developing the code, having one respondent is actually help us more have better control over the coding scheme. And if we have, like, let's say 5, in some cases there were 3 to 5 witnesses at the same time, it might be more difficult for us to kind of control for the coding scheme. So I think it's a good thing to start with one, with hearings that we have only one witness, so we can better make sure that what we code and what we see control for that one person, which again, as Dima just mentioned, is very influential to begin with.
I think cool.
So let's move to Yangkun and Sini. Do you want to respond to what Roxana commented?
Okay, thanks a lot. Really thanks for your suggestions. As you said, the reason why we write this article is starting from the state court that there is a few research related to Chinese and the empirical perspective. And your advice is really helpful, and we will polish our article and improve our explanation, giving more details and introduction of Chinese legal practices in protecting Chinese personal information. And we will try to give more details and helping improve the empirical windows to other countries, especially some countries whose situation is like China. To improve the data protection in their country. Okay.
Very much. And Brenden and Milton, do you want to respond to what Roxana said? And then we will move to the Q&A.
Sure. Thanks, Roxana, for your comments. And thank you to everyone for the opportunity to present. So I think it's kind of important to point out how especially with Doe, and the advertising ID, that the platforms are responding to substantial demand for privacy without really public oversight or direct regulation. You see that in their efforts, whether it's DOE or restricting the identifier for advertising in the case of Apple. So I think that's important to point out. With regard to kind of standardization, I guess, and the influence of who's shaping the standards, I think that's pretty obvious. In the case of DOE in particular. But I'm not quite sure, and I'm not quite sure that's problematic. So if they are the dominant platforms, yes, but they do seem to be responding to demand for privacy coming from just general norms of improving privacy for the individual. And it's having dramatic effects on industry structure, both in mobile identifier for advertising as well as DNS resolution. So I don't know if Milton wants to add anything. I know I think he's in a meeting room somewhere in Poland. Yeah, he makes the point, yeah, standardization processes are always influenced by the major providers. It is important to point out that Google, they could have, having all the data, DNS query data at the browser endpoint, they could have, approached it by controlling all that data, but they didn't. And in fact, there's IETF work going on to kind of standardize how users will interact with the network and select their resolution provider. So to their defense, I think they are really pushing or have a strong concern for privacy in that regard. So.
Great, thank you, everyone. Or Milton, do you want to add something else before I move to the Q&A? No, you're good. Great. So if it's okay with everybody, I'm just going to move. There's a couple of questions which I'm going to read, and then the people whose papers is mentioned there, if you can answer, that will be great. So Evelyn Nusalim is from Indonesian Food Safety Institute in Indonesia. Her question is for Sini and Yangkun about does China, I think you answered in the messages, but if you can say that, because I think it's quite interesting for all of us, does China has a privacy or data protection law, and how can we get it? Thank you for your response. So Yangkun?
Hello. So yes, actually, China's personal information protection law has been formally passed into law, and it's going to come into effect on November 1st, 2021. But I'm not sure if there is an English version of this law. If anyone is interested, we can assist with the translation. Okay.
That will be amazing, and maybe we can continue this discussion in the mailing list, because I think that a lot of people would be quite interesting, including myself. So thank you very much.
Okay, thank you.
And Anke Obendik, I hope that I'm saying your name correctly. They are asking a question to Chelsea. Is your conclusion that Facebook has improved? And to what extent do you think that this conclusion might come from the fact that the analysis is, based purely on Facebook newsroom articles? How does this theoretical framework help you there? And then the next question is for Dmitry, but first, if you can answer that. Thank you.
Yes, and thank you, Anke, for your question. So the newsroom articles are my primary focus for a couple of reasons. One, it's the historical data on the changes itself is not readily or publicly available. Maybe I might be able to get access to it one day, but it's the historical data that I have is how Facebook chooses to announce it. Interestingly, though, out of this challenge of looking at history, it presents a promising opportunity to look at how does Facebook actually want to say that they're responding to inflection points, to regulatory actions, to social pressures, how they want to frame their response in the privacy updates. So we can see kind of how their public facing, at least, presentation of these updates comes across. And so the theoretical framework of looking at what are the normative concerns of deceptive practices, because Facebook has been for at least over a decade accused of having deceptive and misleading practices when it comes to privacy and data policies, I think is helpful in looking at how they're responding to these social, economic, and legal concerns. In terms of, I didn't make a conclusion if it's improved or not. It's more looking at how they're responding to evolving expectations of privacy based off of these different notes. So it also contributes to this growing literature that's acknowledging that there's a need to shift from privacy as an individual responsibility, so that control, to perhaps larger social concern. So working towards those solutions, I think is where we're shifting. And so that's where I think the really promising discussions will hold in the future.
Great, thank you very much. And the rest of the question is for Dmitry and Rotem. Sorry, my computer just jumped. Could you elaborate a little bit on the ideological differences that you found?
Sure. Thank you for the opportunity to tell more about this. So there are a few things that we observed in terms of ideological differences when we compare Republican and Democratic senators. So first difference that we find is in the frequency and the kind of dominance of primary and secondary privacy relationships in the discourse of the senators. We see that relatively speaking, the Democratic senators are emphasizing the second, well, that's what not emphasizing, but they talk more about the secondary privacy relationships as opposed to Republican senators. And that is true for both vertical and horizontal relationships. And this is interesting because Cambridge Analytica scandal is primarily about, the secondary vertical privacy breach. So we see that Democratic senators talking relatively more about the secondary relationship, whereas Republican senators emphasize the primary privacy relationships. And it's interesting because it seems like almost as putting the individual responsibility at the agency of an individual user in the center of how they view the issue. Additionally, when talking about responsibility attribution, we find that Democrats used stronger infringement responsibility framing compared to the Republican counterparts, meaning kind of for Democrats were, I guess, placing more blame with with various actors, primarily Facebook, for the Cambridge Analytica case, whereas the Republican senators tended to do it less frequently, which again kind of speaks to this notion of personal responsibility as opposed to institutional responsibility in this case. That's it, I guess.
Very much. I think the next question is from Milton Mueller. He has a question to Yangkun. Is China's law really a privacy protection for individuals, or is it more an attempt to nationalize data on the part of the CCP, given that China does not allow, sorry, my screen is really small. Given that China does not allow encryption of application block TLC 1.3 has unmitigated access to social media providers' data. Yangkun, please.
Okay, hello. Thanks for your interest in our Chinese data protection. I think you asked two questions. So first of all, for the purpose of legislation, I find it very difficult to answer whether it's for protection or for control of the party. There are many voices in society. Yeah, so I think it's very hard to answer the question. And the second question is, has mitigated access to social media providers data? No, because I'm also a Weibo crawler developer. Actually, there are limitation. There is a upper limit for the access to social media providers data. It's not an easy way to get all the social media data in our Weibo sites in China. Okay.
Thank you very much. Are there any more questions? I have a question to Chelsea. Thank you. I'm going to intervene. Obviously, this is a topic that really interests me, and I was wondering if you were looking at the kind of the new framework that is trying to be passed through the online safety bill, which is around care by design, which is obviously influenced by the GDPR. And if you have any thoughts, how does that relate to dark patterns?
Oh, interesting. I haven't seen the two of them together, but the main thing is that I think dark patterns and which is trying to bridge a whole different field of scholarship from different fields, which I think is why there's this push towards trying to adopt that language. But the history of and sludge, market manipulation, these concerns have existed for a long time. But I think that really the concern is how to introduce fairness back into an online world where it's becoming increasingly, maybe not unfair, because that would be arguable to say it's unfair, but challenging in terms of the information overload and the quantity of options that I almost said a student, that a user has to engage with. So I think that at this point, any sort of solutions that are trying to move towards having fairness back into the online world is a good step.
Fantastic. Thank you very much. There is a question that seems like the answer can take us the whole conference. So I don't know if some of the participants want to comment on that. Can the panelists comment on the perceptions of what is privacy and how has the perception changed as the internet has become popular? I think the answer is quite long. So if people can maybe just comment really swiftly, maybe in relation to their paper, how they think that privacy has changed or not within their sort of case study. Maybe I'll jump to Dmitry or Rotem or whoever wants to jump in.
Not sure if I have.
I'll jump in.
Okay, go ahead, Brenden.
Go ahead, Dmitry. No, I'll just say I think the changes that are happening with DOE and the advertising identifiers being restricted. I mean, these are pretty substantial changes with major industrial kind of organizational effects. So they're very important in that regard. I'm looking at Dmitry's comment here. How do commercial actors make decisions about profit versus security? I mean, I don't think, the major platforms that are engaging in DOE and restricting identifiers, I don't think they're necessarily trading those two concepts off, actually. I think they're doing both. The interesting questions that need to be explored a little more are the competitions between these platforms, and in particular between the U.S. and China. Actually, those are the platforms. Huawei is making movements into trying to create the same type of ecosystem that Apple has and Google has, and there need to be investigations there about how data is treated and what are the ramifications for users generally.
Yangkun, do you want to maybe briefly say how privacy has changed maybe in your case study?
you mean what is privacy in my studies?
Yeah, I'm trying to think a very broad question and trying to narrow it down to people's case studies. So the question was around, how privacy has evolved since the beginning of the sort of commercialized internet. So let's just focus on your case study and what do you think are sort of key insights from how privacy has changed in your case study?
Okay, actually, in my studies, for what is privacy, I think privacy is something we won't want to put it on public. Yeah, all the personal information that we don't want to put in public are the privacy. And how has the perception changed as the internet has become popular? For this question, I think as the internet has been popular, our perception of the what is privacy has changed a lot. And for example, something like our names, like the telecontext has been a part of the privacy and a part of personal information. So I think the scales and the range has been extended widely. Yeah.
Fantastic. And maybe Chelsea, just for 1 minute, and then we might start to close the panel.
Certainly. I think that before privacy was seen as, well, Mark Zuckerberg claimed that privacy was not really a social norm. And so back in 2010, so we're seeing a transition now that there is at least a desire to have more privacy. And I think that we can see that in the settings changes themselves. One of the big ones was they first switched teens privacy settings automatically from public to friends. And then a year later, that switched to everyone switched from public to friends as defaults. So there was this, I think that's a really key example of how defaults have normative values, but also how they can, how they're reflecting changes in user preferences.
Fantastic. And I'll give Dima a very brief time for answering this as well, and then we can close the panel.
Sure. Thank you, Elinor. So, from the kind of perspective that we adopt in this and a number of other projects, for me, this distinction between vertical and horizontal orientations of privacy is gaining kind of critical importance. First, because it seems like the public's predisposition is to think about privacy primarily in horizontal terms, unless there are kind of exogenous shocks like Cambridge Analytica, even then it's temporarily. And second, that there is a lot of emphasis on questions of literacy and giving people more control over their privacy online, which sometimes seems as more kind of shifting responsibility from the institutions to individuals in a situation where individuals are kind of inherently disempowered compared to the institutions in dealing with privacy. So that would be my cent on the topic.
Fantastic. So I think that we can sort of say thank you for all of the presenters and of course, Discussant for their really great insights. And thank you everybody for being on time in all of the sessions. I think it was a super interesting session that sort of is a really good starting point for the rest of the conference. I'm reminding you that we have double sort of parallel sessions today. And it will be great to see you in the next sessions as well. I will say thank you to Chelsea, to Dmitry, to Rotem, Yangkun, Sini, Brenden, and Milton. If you want to tweet about this, of course, you can use our hashtag, which is GigaNet 2021. We're going to have a 5-minute break, and then we will reconvene in 22, whichever time zone you are. So see you very soon. And thank you, everybody, for a really great discussion.